Our next topic is one of our favorites. Panel 3 is Reconstructing First Principles, the 14th Amendment, and the Constitution. Here to introduce and moderate this panel from the United States Court of Appeals for the Seventh Circuit, Judge Diane Sykes.
Good afternoon, everyone. And as you've just heard, we'd like to turn our attention this afternoon to the 14th Amendment, which, to state the obvious, dramatically changed our constitutional law. Scholars and Supreme Court justices continue to debate the proper understanding of the 14th Amendment, in particular, the foundational questions of how and to what degree the amendment altered the federalism that is both explicit and implicit in the original constitutional design, and also which part of the amendment secures individual rights against state interference. Your friends here at the Georgetown Law chapter of the Federalist Society have assembled an all-star panel to discuss and debate this broad and important topic. Professor Kurt Lash will get us started this afternoon. He's seated at my far right. Professor Lash holds the E. Claiborne Robbins Chair at the University of Richmond School of Law, where he teaches and writes about constitutional law and constitutional history. He is the author of countless articles and several books on the Constitution, most recently the Reconstruction Amendments, the Essential Documents, and the 14th Amendment and the Privileges or Immunities of American Citizenship. Before moving to the Richmond School of Law, just last year, I think, he was on the law faculty at the University of Illinois, where he held the Guy Raymond Jones Chair in Law and was co-director of the program in Constitutional Theory, History, and Law. Professor Lash holds a BA from Whitman College and a JD from Yale Law School. Next up is Professor Nicholas Quinn Rosenkranz. We're not exactly seated in the right order here, but I think he's well known to all of you here at Georgetown. Professor Rosenkranz teaches constitutional law and federal jurisdiction right here at Georgetown Law. He is the author of 2 influential law review articles about constitutional interpretation and judicial review, the subjects of the Constitution and the objects of the Constitution. Before entering law teaching, Professor Rosenkranz served in the federal government in the Justice Department's Office of Legal Counsel, and he clerked for my colleague at the Seventh Circuit, Judge Frank Easterbrook, and at the Supreme Court for Justice Anthony Kennedy. He is a graduate of Yale University and Yale Law School. Third in line this afternoon is Professor John Harrison, the James Madison Distinguished Professor of Law at the University of Virginia School of Law. That has a nice ring to it, doesn't it? He teaches a vast array of subjects, including constitutional law and history, legislation, federal courts, civil procedure, remedies, corporations, and property. He has written dozens of articles on constitutional law and interpretive method, constitutional history, and judicial review. Professor Harrison, too, served in the Justice Department in several different capacities, including as Deputy Assistant Attorney General in the Office of Legal Counsel, and he worked in private practice here in Washington, D.C. Professor Harrison clerked for Judge Robert Bork on the D.C. Circuit and is a graduate of the University of Virginia and the Yale Law School. Our final panelist today is Elizabeth Wydra, the president of the Constitutional Accountability Center, a think tank, public interest law firm, and action center here in Washington, D.C. For those of you who are not familiar with its work, you probably should be. The center conducts scholarship and participates in litigation and other forms of public advocacy to promote the view that the Constitution is, in most essential respects, a progressive charter. The center was launched in 2008, and Ms. Wydra, I believe, was there at the creation.
Yes, definitely.
She joined the center after a top-shelf appellate and litigation practice, most recently at the San Francisco office of the Quinn Emanuel law firm. Ms. Wydra clerked for Judge James Browning of the Ninth Circuit Court of Appeals and is a graduate of the Yale Law School. So we have 4 Yaleys this afternoon. With that, I'll turn the podium over to Kurt Lash.
Thank you, Judge Sykes. Thanks to the Federalist Society and thanks to Yale Law School, I guess, for creating such a wonderful panel. My role this afternoon is to talk about the creation of the 14th Amendment and its impact on the founding principle of constitutional federalism. My conclusion, in brief, is that although the 14th Amendment dramatically expanded the list of rights that citizens can assert against the states, it does so in a manner perfectly consistent with the principles of Madisonian federalism, and in fact, the man who drafted Section 1 of the 14th Amendment insisted that those Federalist principles be preserved as the country moved forward. Okay, so the story of the 14th Amendment. It begins on December 4th, 1865. This was the opening day of the 39th Congress. The Civil War was over. The 13th Amendment was moments away from ratification, and the representatives of the former rebel states stood at the doorway to Congress waiting to be readmitted to the seats that they had abandoned 4 years before. They were left there, left literally standing at the door. Defying the President of the United States, the Republicans in Congress refused to readmit the representatives of the former rebel states. Instead, Republicans went about trying to determine when the southern states could be safely readmitted to the Union. There were two big problems that first needed to be solved before those representatives could retake their seats. First, the freedmen in the South needed to be protected from the infamous Black Codes, which had denied freedmen the equal rights of citizenship and the equal protection of person and property. But second, and even more importantly, Congress had to prevent Southern Democrats from taking over Congress once they were readmitted to the Union. This was a distinct possibility, ironically enough, because of the passage of the 13th Amendment. Under the original Constitution, slaves counted as 3/5 of a person for the purposes of slave state representation. Now that those slaves were free, they would count as a full 5/5 of a person and automatically increase the political power of traitors of the Union. Congress could not let that happen. So, in addition to protecting the rights of the freedmen, Republicans had to find some way to constrain the political power of the southern states before granting them readmission. Now, as many of you know, these two problems eventually would be solved by Sections 1 and Sections 2 of the 14th Amendment. But first, Congress had to decide whether an amendment was needed at all. Radical Republicans insisted that Congress enjoyed unlimited power to reconstruct the country. Radicals rejected the theory of federalism, and they dismissed the 10th Amendment as irrelevant in a post-Civil War world. According to this view, Congress had no need to go to the people asking for a new amendment, granting them new powers. Congress could move immediately, and do so by way of legislation, like the Civil Rights Act of 1866. Not everyone, however, in the 39th Congress accepted the radicals' nationalist view of the Constitution. Moderate and conservative Republicans agreed that Congress needed to act, but they insisted that the Constitution, properly interpreted, constrained the powers of the national government. Before Congress could act, the people must grant Congress power to act by adding a new amendment to the Constitution. And one of these moderate Republicans was John Bingham, the author of Section 1 of the 14th Amendment. Bingham agreed with the goals of civil rights legislation, but he insisted that in pursuing those goals, they had to pass a new amendment. And until that happened, the 10th Amendment prohibited the very legislation that Congress was trying to pass. Speaking to his colleagues in the House, Bingham insisted that Congress follow the principles of James Madison. And he quoted to his colleagues Federalist Papers number 45, and I quote, "The powers reserved to the several states will extend to all the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people and the internal order, improvement, and prosperity of the state." This Madisonian principle, Bingham declared, was written into, quote, the very text of the Constitution itself, the 10th Amendment. And he quoted the amendment to his colleagues, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people," end quote. Bingham believed in a constitution of enumerated national powers and enumerated national rights. All non-enumerated subjects were reserved to the people in the states. And what the Constitution lacked, Bingham insisted, was a clear statement requiring the states to respect the enumerated rights of national citizenship, particularly those listed in the first 8 amendments, the Bill of Rights. Although applying the Bill of Rights against the states would have the effect of expanding the list of subjects constraining states already listed in Article 1, Section 10, neither Bingham nor any of the other moderate Republicans wanted to transform the basic Federalist structure of the original Constitution. The federal government would remain a government of limited enumerated power. And it was precisely because of their continued belief in the Federalist Constitution that moderates like Bingham and the other Republicans insisted that an amendment was necessary in the first place. Bingham therefore proposed an amendment, one empowering Congress to enforce the privileges and immunities of American citizenship and the equal due process rights of all persons. His proposal ultimately became Sections 1 and 5 of the 14th Amendment. Those amendments would solve one problem, but more was needed to be done before it was safe to readmit the Southern states. Other members therefore proposed an additional amendment that would prevent the incoming rebel Democrats from taking over Congress. Representation in the House would be based on all persons in a state, black and white, but only if the state agreed to give both black and whites the right to vote. If a state refused to enfranchise the freedmen, its representation would be proportionally reduced. Then additional proposals were added, one that prevented rebel oath breakers from holding political office, and another one which prohibited slave owners from receiving compensation for their emancipated slaves. All of these proposals were gathered together into a 5-sectioned amendment, the 14th. Bingham, at the time of proposal, insisted that this amendment maintain the basic principles of constitutional federalism. And in fact, as the amendment went before the states for ratification, Bingham continued to fight for the equal rights of the states. Midway through ratification, a group of radical Republicans led by Thaddeus Stevens tried to convince their colleagues that the proposed amendment was not actually necessary and that Congress had full power to control the internal laws of the southern states, even to the point of kicking out of the Union any readmitted state that later misbehaved. Once again, it was John Bingham who stood up for the principle of limited national power and independence of the states from federal control. According to Bingham, and again I quote, "Sir, I'm not to be thus driven into a violation of the letter and spirit of the Constitution of the country. Under it, the rights of the states are as sacred as those of the nation. Its express provision is that, quote, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. The equality of the states and the equality of men in the rights of persons before the law is what the Constitution enjoins and the people demand." End quote. Bingham prevailed. A congressional majority rejected Stevens' proposal, and they stood by the proposed 14th Amendment and its vision of limited national power. By the summer of 1868, a sufficient number of states had ratified the amendment, and on July 28, 1868, 150 years ago this summer, Secretary of State William Seward declared the amendment was now part of the federal Constitution. Not long afterwards, Congress quietly repassed the Civil Rights Act. This time, they had constitutional power to pass such legislation, and this time John Bingham supported the bill. In the end, the country received an amendment that radically transformed the nature of the Bill of Rights, but which preserved the original vision of constitutional federalism. Henceforth, the enumerated rights of citizens, such as those listed in the first 8 amendments, were protected against state abridgment, and the enumerated powers of Congress were increased in order to secure those rights. But all non-enumerated subjects remained under the control of the people in the several states so long as they conformed to the basic principles of due process and equal protection. Now, one of those non-enumerated rights that remained under state control even after the 14th Amendment was the right to vote. States remained free to deny freedmen the franchise so long as the state was willing to accept reduced representation in Congress. To men like Frederick Douglass, former slave and statesman, that was unacceptable. If the unenumerated subjects of local municipal law were to be left to the voting people in the states, then the voting people in the states should include both black and white votes. But even as Douglass called for a 15th Amendment, giving blacks the right to vote, Douglass nevertheless recognized the need to preserve a Federalist Constitution that limited the power of the national government. And I'll close by quoting Frederick Douglass. Quote, "The Civil Rights Bill and the 14th Amendment do not reach the difficulty and cannot, unless the whole structure of the government is changed from a government by states to something like a despotic central government with power to control even the municipal regulations of the states and to make them conform to its own despotic will. While there remains such an idea as the right of each state to control its own affairs, an idea, by the way, more deeply rooted in the minds of men of all sections of the country than perhaps any one other political idea, while that's the case, no general assertion of human rights can be of any practical value. To change the character of government at this point is neither possible nor desirable. All that is necessary to be done is to make the government consistent with itself and render the rights of the states compatible with the sacred rights of human nature, end quote. And this, Douglas believed, could be accomplished by giving every loyal citizen the elective franchise. Douglas got his wish. We passed the 15th Amendment. And together with the 14th and 15th Amendments, we have expanded individual freedom while preventing the creation of a, quote, despotic central government. Federalism prevents such despotism, and federalism was preserved by the 14th Amendment. Thank you.
Okay, so that was great. Kurt's story starts in the 1860s. Mine actually starts 30-some years earlier. A case that I wonder how many of you, actually, maybe show of hands, have you read Barron v. Baltimore? That's pretty good. That's very good, actually. I teach federal courts here at Georgetown. I teach it out of the magnificent magisterial Hart and Wexler casebook, which covers 2,000 cases. And there is no mention of Barron v. Baltimore. It does not show up in that casebook. I don't know why. Barron v. Baltimore, I think, is like a crucial case for understanding the 14th Amendment. So I'm going to talk a little bit about that, and I'm going to be applying an expressly sort of textualist lens to some of the questions of the 14th Amendment. So, okay, in Barron v. Baltimore, Chief Justice Marshall, by the way, you read all these very nationalist opinions by Chief Justice Marshall. It's probably the most important pro-federalism opinion by Chief Justice Marshall in this era, and it doesn't get as much attention for some reason. So in 1833, Chief Justice Marshall is confronted with the question, does the takings clause of the Fifth Amendment apply? To whom does it apply? To whom does it apply? So it says private property shall not be taken, and this is the passive voice. So it begs the question, taken by whom? Right? Shall not be taken by whom, right? Begs the question, and the issue in the case, does that bind the states? Does that bind the states? Okay. The passive voice, famously confusing about quite who it applies to. It's actually used often to elide this question, to kind of leave vague quite who is being bound. So it's a sort of a tricky question. Chief Justice Marshall, though, doesn't give up. He says, okay, it's written in the passive voice, but we can figure this out anyway by looking at some other clauses of the Constitution. So he takes a look at Article 1, Section 9, and he sees that most of Article 1, Section 9 is likewise written in the passive voice. It says some things like no bill of attainder or ex post facto law shall be passed, right? Shall be passed by whom, right? By whom, passive voice. But Article 1, Section 10 has some of the exact same restrictions as Article 1, Section 9. For example, it says, Article 1, Section 10, no state shall pass any ex post facto law. Okay, so so Chief Justice Marshall reasons if the Article 1, Section 9 version covered states, then the Article 1, Section 10 version would be superfluous, right? So the Article 1, Section 9 version, no ex post facto law shall be passed, must govern just the feds, not the states. Okay. Then he makes this, so first of all, notice, I mean, this is extremely sophisticated textual analysis, right? He's moving from clause to clause of the Constitution. The case is about the Fifth Amendment, but he's looking at Article 1, Section 9, Section 10 to figure this out. So he figures this out and figures out that the Article 1, Section 9 passive voice must bind only the feds. And then he comes up with this makes this crucial move, which is to presume grammatical consistency throughout the document. So he says if the passive voice only binds the feds there, it must only bind the feds everywhere. So, and therefore, because the Fifth Amendment's written in the passive voice, it also must bind only the feds, and by the way, probably the whole rest of the Bill of Rights as well. So that's why the Bill of Rights doesn't bind that's the logic of why the Bill of Rights, how Marshall finds the Bill of Rights doesn't bind the states prior to the 14th Amendment, right? It's a crucial federalism idea, but I want you to notice these textualist moves here. The ninth section having enumerated, now I'm quoting, the ninth section having enumerated in the nature of a Bill of Rights the limitations intended to be imposed on the powers of the general government, the 10th proceeds to enumerate those which were to operate on the state legislatures. These restrictions are brought together in the same section and are by express words applied to the states. No state shall. So, and then if the original Constitution in the 9th and 10th sections of, of the first article draws this plain and marked line of discrimination between limitations it imposes on the powers of the general government and on those of the states, if in every inhibition intended to act on state power words are employed which directly express that intent, some strong reason must be assigned from departing for this safe and judicious course in framing the amendments before that departure can be assumed. That is, we have to assume that those who framed the amendments would use the same grammatical presumption as those who framed the original document. Had the framers of these amendments intended them to be limitations on the powers of the state governments, they would have imitated the framers of the original Constitution and have expressed that intention. Okay. So now we're up to the 14th Amendment. John Bingham sits down to write the thing, and what he's wanting to do expressly, he says, is overrule Barron v. Baltimore. How does he do it? He sits down and reads Barron v. Baltimore and says, aha, if I'm the drafter of an amendment, what I need to do here is imitate the framers of the original Constitution and express the intention. Thus, the 14th Amendment ringing language, no state shall, right? No state shall, okay? So first I want you to sort of see the kind of textual story that got us to no state shall. No state shall is an echo of Article 1, Section 10, and the Constitution had seen that language before, and Bingham is echoing that on purpose. And he's echoing some other things too. I mean, notice that the 14th Amendment sounds in a way a bit like the First Amendment. No state shall make or enforce any law. Congress shall make no law. So it's got these key words, make, law. It's a prohibition, no. So it sounds a little like the First Amendment, prohibiting the making of law. But the formulation is different from the First Amendment or anything else in the Constitution, because it says no state shall make or enforce. No state shall make or enforce. Now why? Why does the First Amendment say Congress shall make no law, but the 14th Amendment says no state shall make or enforce any law? Why is that? There are a couple of possible reasons. One is states already had lots of discriminatory laws on the books, right? So Mississippi could have said, you know, we're not making any laws discriminating against folks. We're just enforcing the ones that we've already got, right? If it had just said no state shall make any law denying anyone equal protection of the laws, for example. So hence it needs to say make or enforce. But there's another and maybe more important structural reason why it has to say that, and it's this. And again, Marshall is onto this in Barron v. Baltimore years and years before. When the framers of the original 10 amendments, the first 10 amendments, sat down to write them, they were limiting the powers of the federal government. So they were limiting powers, powers that are granted in the document itself. That is, each amendment, in a sense, corresponds to some grant of power. Congress has granted some powers, but then the Bill of Rights cuts across those powers. The president shall take care that the laws, so Congress passes a statute banning the possession of drugs. The president shall take care that the laws be faithfully executed. You could have believed that a president could believe he should strip search everyone to see if they have drugs, right? But the Fourth Amendment cuts across that, cuts across the take care clause and says he can't do that, right? His searches have to be reasonable. So the original Bill of Rights cuts across powers that are granted in the document. The 14th Amendment, though, doesn't. It's restricting powers that the document didn't itself grant. And the states all have different structures, subtly different structures. So when the framers sat down to write the First Amendment, they could be confident, they could know that the threats they were worried about as to speech, as to religion, were threats from Congress. They were worried about Congress abridging your free speech rights, for example. But from the states, they couldn't quite be so sure. Because who knows? Different states have different structures. And it might be that in one state, the governor is really the threat to your free speech rights. And in another state, it really is the legislature. So they can't quite be as sure. Hence, instead of saying something like, no state legislature shall X, it says, no state shall make or enforce. Okay. Now, Akhil Ahmed, in his brilliant Bill of Rights book, suggested that the 14th Amendment incorporates the Bill of Rights against the states, but as it incorporates them, it refines them. That is, they change a little bit, and they change in some subtle ways. What you have to do, on Akhil's view, is separate out the individual rights components of the Bill of Rights and then think about filtering those things through the 14th Amendment. That's a hugely powerful insight, but I'm wanting to add to that insight with the following thought. Yes, the content might become refined as it passes through the 14th Amendment, but perhaps even more important, the subjects might become refined as they pass through the 14th Amendment. So, the First Amendment says Congress shall make no law. It seems like it binds only Congress at the federal level. But when the freedom of speech is incorporated against the states through the 14th Amendment, it might be that that your freedom of speech rights against the states is against different actors, against both the state legislature and the state executive, and possibly the state judiciary. So there might be a refinement, not just of the content of your speech rights, but actually of the object of them, the government actor against whom you hold these rights. And so I'm going to just leave that as a question for you to think about. Do the objects of these rights change when incorporated against the states? Thanks.
Thank you. The order in which we are speaking is not an accident. We had a conference call, we talked about what we were going to say, and Judge Sykes decided in what order we would speak.
It's good to be the judge.
The fact that I'm the only person on the panel wearing a yellow necktie is an accident. There was no coordination on that. We did not discuss fashion choices. I happened, and I'm glad that this is true because this is the example I prepared, and it turns out to have worked. And I decided to wear a yellow necktie. My claim is going to be that the transformation of American constitutional law through the 14th Amendment reflected in specifically the Supreme Court's current doctrine about the second sentence of the first section of the 14th Amendment, specifically what they call substantive due process and equal protection, is an accident. It is not the result of the kind of deliberated, thought-through process that Judge Sykes went through in deciding in what order we would speak. An example of a part of the Constitution that is the result of a thought-through process, you heard this morning, the Federal Convention's decision to have a single person hold the executive power. They talked about that at the Federal Convention. They considered alternatives, chose what's in the Constitution quite consciously. People involved in the ratification process understood what the Federal Convention had done, chose to ratify or vote against the Constitution, perhaps not for that reason, but knowing what they were doing. As I say, a deliberated process. I'm going to say that the path that took us to the Supreme Court's doctrine is not like that, but again, an accident. Now let me say that when it comes to matters of interpretation, I'm a text formalist. So when I say that a meaning was achieved by accident, was an unanticipated consequence of decisions, that does not bother me. That's the great thing about being a text formalist. We love accidents. So I'm talking about constitutional history and constitutional politics here, and not necessarily about the meaning of the 14th Amendment under the kind of textualist canon that I would adopt. Substantive due process and equal protection, as the Supreme Court currently knows them, are vague. They are fuzzy, and they are, more importantly, as Hart and Sykes would say, standards. That is to say, they are vague provisions, or at least vague concepts, that require a lot of normative thinking in order to apply them to particular situations. So the substantive due process idea that all government decisions must be rational, there are fundamental rights, that requires a lot of normative judgment. The equal protection doctrine that says that all decisions made by state governments are subject to a general requirement of equality, whatever that means, requires a lot of normative judgments. It's well understood that legislatures, A, frequently adopt standards on purpose and as the result of a deliberate process. And when they do that, they are in effect delegating granting authority to future decision makers. That's how standards work. They set out basic concepts, sometimes they use exemplars, but they leave a lot of normative judgments to be made. I'm going to say that did not happen in the construction of the 14th Amendment in such a way as to produce, through a deliberate process, the due process and equal protection doctrines, not clauses, that we have. To see that, it's important to distinguish between vagueness, which I've just discussed, and which is a feature of standards, and ambiguity. And when I say ambiguity, I'm using it correctly, unlike the Supreme Court of the United States, which frequently, especially in its Chevron cases, uses ambiguity to mean simple unclarity. No. When I say ambiguity, as in ambidextrous, I mean a statement, a word, whatever, some linguistic object, that has, since it's ambidextrous, two reasonably well defined and distinct possible meanings. Two distinct meanings. That's different from vagueness. For example, the numeral 100 is functionally today ambiguous. It's also, for those of you who want to go beyond just two possible meanings, beyond that, concepts, words, it can be multivalent or polysemous. That's a whole lot, two or more. 100 is actually multivalent or polysemous because there's a different meaning for 100 for every possible base. But since people only talk about base 10 and base 2 these days, functionally speaking, 100 is ambiguous, two possible meanings. And the possible meanings of those numerals are 100 and 4. They are quite distinct from one another. They are both numbers and so quite reasonably well defined. It is common, as I said, for legislators deliberately to choose vagueness. There are reasons for doing that. It is not so common, because it is frequently, I would say generally, irrational, deliberately to choose ambiguity. Maybe a law professor could come up with an example in which a deliberative body would want to have either 100 of something or 4 of something, leave that decision to be made in the future, and communicate that message by using the numeral 100. I don't think so. Ambiguity, as opposed to vagueness, is a very bad tool. I'm now going to say that with respect to the Supreme Court's current reading of the Due Process and Equal Protection Clauses, the best you can say about that reading is that the clause is ambiguous as between that reading and another reading that I'm going to discuss, one for each clause that was well known at the time of the framing of the 14th Amendment, and to say that that decision was made on purpose to have one or the other of those two well-defined and reasonably clearly distinguished meanings impossible either historically or in principle to attribute to Congress, the Congress that framed the 14th Amendment. First, due process. Kurt Lash talked about John Bingham. There's a great moment during the debates over the 14th Amendment when somebody asked Representative Bingham, what does the Due Process Clause mean? And Bingham answered, the courts have answered that question long ago, and the gentleman can go and read their opinions. If Bingham's interlocutor had gone and read the opinions of antebellum courts under due process clauses, primarily state due process clauses, he would have come across a very well-known component of 19th century American constitutional law. He would have found the doctrine of vested rights due process, which protected vested rights of property against direct legislative alteration. The idea that the legislature cannot directly alter vested rights of property was for 150 years the basic doctrine of American constitutional law, as Corwin called it. It arose from a reading of the Due Process Clause that is not entirely lost, but frequently neglected today. According to that reading, due process of law means what a court does, what Judge Sykes does. The decision of a particular case pursuant to existing law. Legislatures do not operate that way. They make and change law. They don't apply it. They are therefore institutionally incapable of providing due process, and as a result, anything a legislature does that qualifies as a deprivation of property is therefore unconstitutional. That was the dominant reading that generated early 19th century antebellum vested rights due process, and as you can tell, it has nothing to do with a general requirement of rationality. It has nothing to do with fundamental rights. It has nothing to do with liberty of contract, with liberty of conduct. The vested rights reading of the Due Process Clause was well known, as I said. Had somebody looked it up, that's what that person would have found. So to say that the framers of the 14th Amendment made the kind of deliberated choice for today's substantive due process that was made with the single person executive would be to say that they understood that there were these two possible readings, what we would now call substantive due process and vested rights due process, and deliberately decided, the way a legislature in deliberately choosing a standard sometimes does decide, not to choose between those two. There's no indication that anybody thought of the decision in the drafting of the 14th Amendment in those terms, and it's hard to see why anybody would. That's like leaving to future decision makers the choice between 100 and 4. Similarly, with respect to the Equal Protection Clause, there was at the time of the drafting of the 14th Amendment a well-known reading of that text that is fundamentally unlike the Supreme Court's reading of the Equal Protection Clause. That other reading, again, well known at the time of the framing, holds that the protection of the laws does not include everything the government does, but rather is a limited and important but limited subset of government activity. The Supreme Court's doctrine, of course, is protection of the laws that has to be equal includes everything, like, for example, public education and political rights. The other view, that it is about protection, narrowly conceived, in particular the remedial processes of government, is in Blackstone. It is in Marbury against Madison, which defines the protection of the laws as the system of remedies that protects and supports rights. It too was well known, and it is fundamentally different from what the Supreme Court says. Again, there's no indication that the drafters of the 14th Amendment focused on those two possible readings, which are, as to which the text is at best ambiguous, not vague, and decided we'll just leave that open. Again, why would anybody want to do that? That raises the question, how could the text be so hard to interpret? Or, if it's not so hard to interpret, how could the Supreme Court's doctrine have emerged? One possibility is the court's doctrine was not even on the table in the 1860s, and it emerged entirely later on. Another possibility, and this one is, I think, more favorable to the hypothesis that the court's doctrine today has something to do with the text, is that more than one reading was in play, maybe including the court's reading, clearly including vested rights due process, clearly including protection narrowly conceived, and that not that there was a deliberate decision to leave that open, but that the people participating in the drafting of the 14th Amendment sort of missed the problem. Not that they chose this ambiguity, but they didn't see it. Rather, what could explain that, and what I'm about to say is especially true with respect to equal protection, a lot of people who participated in the drafting of the 14th Amendment, and probably its ratification, very likely had only a rough idea of what the second sentence of Section 1 did. Their rough idea probably was that one way or another, it would eliminate the black codes. And more broadly, it would eliminate race discrimination with respect to civil rights, the right to own property, the right to make contracts, the right to access to court to protect your other rights. Not, notice, political rights. A lot of people probably had a rough idea that it would do that, and no more than a rough idea, and in particular, didn't have any particular notion about how the text would accomplish that goal. I want to stress, to say that somebody has only a rough idea of what a text means, a participant in the drafting process or legislative process, to say that that person has only a rough idea of what the text means, how it does what it does, is not to say that that person believes the text to be a vague standard. For example, a tax lawyer might know that some provision of the Internal Revenue Code has an anti-abuse component, they have them, but not know whether the anti-abuse component is a rule, as they sometimes are, or a standard, as they sometimes are. Now, how would it be possible for the 14th Amendment to be adopted with a lot of people participating in the process having only a rough idea about the second sentence of Section 1, and hence never having made a clear choice to embrace ambiguity in either the due process or the equal protection clause? How is that possible as an historical matter? I'm going to say something that's true in general about the second sentence of Section 1, and then something specifically about equal protection and anti-discrimination. As Kurt Lash said, the key to the 14th Amendment was Section 2. We know it was the key to the 14th Amendment because as far as the supporters of the 14th Amendment were concerned, it was about their political power. And so it was extremely important to them. Section 2, dealing with the unanticipated consequence of the 13th Amendment, was a political imperative for the Republicans. So if you were a supporter of Section 2, the political imperative, you might well not pay a whole lot of attention to exactly how the second sentence of Section 1 does whatever it does, eliminates the black codes. The details don't matter. What really matters is Section 2. So again, there could have been a lot of support for the 14th Amendment, including Section 1, of people who had good reason not to have thought so much about what it meant, because they were in favor of pretty much anything that went in that general direction as long as they got Section 2, which was about their political power. There's another historical explanation that has to do specifically with anti-discrimination and hence with the Equal Protection Clause as it's interpreted by the court. An important part of the drafting in early 1866 in the Joint Committee of Reconstruction was when the Joint Committee considered whether to have an explicit ban on race discrimination that mentioned race, was explicit in that sense. They decided not to, very likely for political reasons, because Republicans were concerned that they were seen as engaging in special pleading for the freed slaves. They thought that reputation was a political liability, so they didn't want to talk explicitly about race in the Constitution. Instead, they used more general concepts. The Supreme Court would tell you that they used the Equal Protection Clause. I don't think that's true because of the narrower concept of protection. I think that the best understanding of the way the second sentence accomplishes the goal with respect to the Civil Rights Act is that they thought the Privileges or Immunities Clause, insofar as it applied to the rights of state citizenship, which are civil rights, property and contract, would be an equality requirement. But however they meant to accomplish it, the drafters moved up a level of abstraction. They didn't talk specifically about race. Does that mean that they deliberately embraced applications beyond race? Again, not necessarily. There can be more general formulations that have one well-established application as to which somebody who uses the general formulation is concerned, or the person using the general formulation is indifferent to other possible applications. Suppose, for example, that somebody wants to talk about me without using my name, and wants to make sure to talk about me, and doesn't really care whether the reference to me refers to anybody else. One way to do that is to refer to people on this panel who are wearing yellow neckties. Turns out that although in principle that might have broader applications than me, in fact its only application is to me, and somebody who wanted to talk about me and didn't care whether or not they were also talking about somebody else might well choose that broader formulation. Same thing with the broader formulation of the equality principle in the 14th Amendment. Entirely possible that a lot of people who participated in the framing and ratification thought that this general concept of equality, whichever clause conveyed it, had a particular application to race and hadn't thought about whether it had any other applications or were uncertain about that because they wanted to get that particular application like my necktie. Now, the last thing I'll say is one little part of the story about, well, if all this is an accident, how did the accident happen? And specifically with respect to the Equal Protection Clause again, a large part of the answer to that question is the Slaughterhouse case, in which the Supreme Court held that the Privileges or Immunities Clause, which again I think was understood to be the principal vehicle by which the anti-discrimination principle of the Civil Rights Act of 1866 was put into the Constitution. Supreme Court held that the Privileges or Immunities Clause applies only to the privileges and immunities of distinctively national citizenship. I think that's wrong, but the court said that. They said that for reasons of federalism, because at the time, Congress was debating what became the Civil Rights Act of 1875. One proposed ground of the Civil Rights Act of 1875 was that Congress had general authority over civil rights, private law rights, property and contract, and so forth. Those debates were taking place upstairs from where the justices were sitting in those days. The majority of Slaughterhouse did not want Congress to have that power, did not think Congress had that power under the 14th Amendment. And so in Slaughterhouse adopted a reading of the Privileges or Immunities Clause that barred that expansion of congressional power. There are other ways to reach that conclusion. I think that, in fact, the Privileges or Immunities Clause does apply to rights of state citizenship, applies a principle of equality, but does not undermine federalism. Justice Curt said its drafters did not want to undermine American federalism. But the court used a different rationale from the one I would have used. And so what they did to the Privileges or Immunities Clause, making it impossible to be the vehicle of the Civil Rights Act of 1866, because the rights in the Civil Rights Act of 1866 are property and contract civil rights. The elimination of that potential reading of the Privileges or Immunities Clause was, as far as the court was concerned, an accident. It was collateral damage. They were aiming at something else, and they blew this up. Well, once the court had blown up the equality reading of the Privileges or Immunities Clause, they knew, and Slaughterhouse says, that somewhere the second sentence of Section 1 of the 14th Amendment eliminates the black codes and forbids race discrimination with respect to civil rights. Well, if the Privileges or Immunities Clause is gone, what's left? The Equal Protection Clause at least has the word equal in it, so why not that one? Well, it won't work to perform its function with respect to the Civil Rights Act of 1866 if it's limited to remedies and protection. So, more collateral damage of Slaughterhouse, blowing up the limited reading of the Equal Protection Clause by accident, and causing the Equal Protection Clause to have to be recruited to refer to everything that a government does. So if you find yourselves wondering why this term, the Supreme Court of the United States, is deciding a case about the Equal Protection Clause and partisan gerrymandering, when, as Kurt indicated, one of the few things that was clearly deliberated and chosen in the 39th Congress is that the first section of the 14th Amendment doesn't apply to political rights. How did that happen? Well, the answer is accidents happen.
You know, John, I was this close to wearing my yellow necktie, so, you really lucked out today. As Judge Sykes said in the beginning, I'm Elizabeth Wydra, president of the Constitutional Accountability Center, and I want to thank the Federalist Society for having me today. I always enjoy speaking at Federalist Society events because I think it's incredibly important to model the type of civil discourse that we have here, even on issues where we might disagree passionately. We can still have a conversation, at least amongst EL law grads. I don't know how it works with everyone else. But, I think especially in this moment, that's very important. That's why I appear on Fox News. That's why I come here, because I think civil discourse, especially on issues about which we disagree passionately, is incredibly important. So thank you all for being here and being part of that discussion. I was especially excited to get this invitation for a Federalist Society event because the prompt was, how should we understand the ways the 14th Amendment dramatically changed constitutional law and federalism? And as my friends and family can groaningly attest, talking about the 14th Amendment is like my favorite thing ever. So I'm really thrilled to be here and having this conversation. So I'll start by saying that the ratification of the 14th Amendment, together with the 13th and 15th Amendments, shook the Constitution to its foundations, which is why we can appropriately and rightly call the Reconstruction Amendments our nation's second founding. And not only back then, but apparently today, some people are still shook. Let's think back to last year's campaign for Senate in Alabama. You might recall reports that surfaced a forgotten 2011 segment on a far-right radio program that featured Roy Moore. Remember him? Oh God, he's not talking here today, is he? Okay, sorry. The program's host said that he wanted an amendment to the Constitution that repealed all the current amendments from the 11th through the 27th. Roy Moore's response to that was revealing. That would eliminate many problems, he said. He said, people don't understand how some of these amendments have completely tried to wreck the form of government that our forefathers intended. Well, if by wreck he meant fixing the flaws in our original design, then Roy Moore was right. If by wreck he meant shifting power away from state institutions and state government officials who had been trampling on people's rights, and instead transferring substantial power to federal institutions and officials more willing and able to protect our rights and freedoms, then yes, that was the entire point of these amendments. As we talk today about how dramatically the 14th Amendment changed our Constitution, it's worth pointing out the irony that is Roy Moore and others like him who clearly understand the progressive arc of our Constitution's text and history. What's more, I think that they fear its strength. Our Constitution has been an imperfect work in progress since the very beginning, but it's also an incredibly resilient document. Our founders designed a constitution that enshrines enduring values, even as it can be amended and has been amended to adapt to changes in our dynamic society. Akhil Ahmed once said that the 3 amendments ratified within 5 years of the Union victory in the Civil War, quote, can only be described as a constitutional revolution. He was exactly right. And given the cause of that war, a bloody rebellion by the southern states to keep 4 million black people in slavery, such a revolution on our founding charter was absolutely required. As you know, America ratified the 13th Amendment that ended slavery except as punishment for a crime, which is a whole nother panel topic to discuss. And the 15th Amendment protected voting rights against racial discrimination. But it was the 14th Amendment that made every person born under the American flag an equal citizen and guaranteed a host of rights to all Americans and to all in America. As my organization has written, the Equal Protection Clause of the 14th Amendment perfected the Declaration of Independence, which had articulated crucial founding principles, but then was betrayed by a text of a constitution that made compromises with slavery and allowed the rights of people to be completely ignored based on the color of their skin. We, the people, rewrote the Constitution by placing into its text that all persons are equal. Not just all men are created equal, not just white men are created equal. By doing so, we brought the Constitution back in line with the founding principles as articulated in the Declaration of Independence. This guarantee prohibits invidious discrimination on a broad basis, on the basis of race, on the basis of sexual orientation, on the basis of gender. This sweeping textual guarantee in the 14th Amendment led most recently, of course, to the Supreme Court's ruling recognizing that marriage equality was the law of the land, a conclusion pressed not only by progressive voices like mine and my organization, but also famously from conservatives and libertarians like Steve Calabresi, Ted Olson, the Cato Institute, with which Constitutional Accountability Center had filed several briefs in support of marriage equality, and others. Something that I referenced earlier, another aspect of the 14th Amendment and many other amendments ratified during and after Reconstruction, I think is largely overlooked by the general public, but notably not by people like Roy Moore. These amendments take power away from the states. In the wake of the Civil War, the drafters of the 14th Amendment felt that the states could not be trusted to protect the rights of all the people, particularly African Americans, but also others. I disagree with Professor Harrison on the limitation of that to race. I think there was a conscious desire to ensure that the rights of all were protected beyond just race-specific and people who had been formerly enslaved. These amendments then shifted that power taken from the states either to the federal government or to the people directly. The framers of the 14th Amendment didn't trust the states to protect fundamental constitutional rights, and they were pretty suspicious of the Supreme Court as well. After all, the Supreme Court had just laid down several years earlier the Dred Scott decision, which had interpreted the Constitution to declare that African Americans had no rights which the white man was bound to respect. The 14th Amendment then lists a series of actions that no state shall take, while explicitly declaring that Congress shall have the power to enforce that amendment by appropriate legislation. Over and over again, in half a dozen other amendments, the 13th, the 15th, the 19th, the 23rd, the 24th, the 26th, we the people ratified shifts of power from the federal government, from the states to the federal government, just like in the 14th Amendment, making our Constitution and our nation more just, more inclusive, more free. The breadth of these specific grants of power, the enforcement clauses, to Congress was no accident, like maybe whether anyone else wore another pink blazer today on this panel, I don't know. But that was certainly no accident. The framers of the 3 Civil War amendments explained many times that the enforcement clauses were written to give Congress a broad power to secure the constitutional rights guaranteed by those amendments. Indeed, they repeatedly made the point that Congress had to have a broad enforcement power if the new constitutional protections were to be effective, and actually enjoyed, in reality, by the Americans they were meant to protect. We obviously have a long way to go still to make all of those rights a reality for all, but that was something that the framers of the 14th Amendment thought about when they gave this enforcement power to Congress. And in fact, because the 14th Amendment's enforcement clause was based so much on the experience from the debates in the 13th Amendment's enforcement clause, I'd like to say a few words about that. In outlawing slavery in the 13th Amendment, and for the first time in our Constitution's history, the 13th Amendment explicitly gave to Congress the power to enforce its provisions through its enforcement clause. Here, in that case, the freedom granted to the men and women formerly held as slaves. In President Abraham Lincoln's words, the 13th Amendment was a king's cure for the evils of slavery, and the enforcement clause was essential to that cure. Passed at Lincoln's urging and ratified by several states in his memory, the 13th Amendment's grant of enforcement power to Congress was critical to secure the protection of fundamental rights and true freedom. Not surprisingly, apologists for slavery objected vociferously to this new grant of power, complaining that it confers on Congress the power to invade any state to enforce the freedom of African Americans in war or peace, and, quote, strikes down the cornerstone of the republic, the local sovereignty of the states. Indeed, in these opponents' minds, the amendment was unconstitutional because it would revolutionize rather than amend the Constitution. It sounds a little bit like someone who just recently lost an election in Alabama. But the fact is, the enforcement powers granted to Congress in the post-Civil War amendments were based on long-standing precedents decided by the Supreme Court far before the Civil War, including McCulloch versus Maryland, which probably you guys have studied in your law classes, I assume, and Prigg versus Pennsylvania, which maybe you haven't, but is an incredibly important case on enforcement power. In McCulloch, Chief Justice Marshall set out the foundational understanding of the scope of congressional power under Article I, that the Constitution explicitly authorizes congressional legislation appropriate to carry out the powers of enumerated in Article I. And McCulloch's formulation, as the Supreme Court has recognized ever since, gave Congress broad regulatory authority. When Congress legislates to carry out one of its enumerated powers, it may use any appropriate means in aid of that power, so long as it doesn't run afoul of any specific constitutional prohibition, as you heard Nick's articulation of the Take Care Clause being limited by the Fourth Amendment. Now in Prigg, the court upheld congressional power while also upholding the Fugitive Slave Act of 1793. Though the framers of the 13th Amendment, of course, abhorred the outcome in Prigg, they incorporated Prigg's understanding of congressional power into the 13th Amendment's enforcement clause. They enlisted it in support of freedom, and as one Reconstruction member of Congress said, turned the artillery of slavery on itself. In giving Congress a central role in enforcing the guarantees of equal citizenship, liberty, and equality more broadly, the framers of the Civil War amendments transformed constitutional understandings of federalism. As America's second founders put it during Reconstruction, Congress could now keep the states within their orbits and in harmony with the Constitution of the country. The 14th Amendment's enforcement clause, for example, as we heard, erased any lingering doubts about the constitutionality of the landmark Civil Rights Act of 1866. And more important, it cemented the idea that in the Constitution, Congress would share with the Supreme Court responsibility for enforcing constitutional rights. Having seen the Supreme Court mangle the Constitution in Dred Scott, the Reconstruction era framers wanted to ensure that Congress could enforce the Civil War amendments, even if a reluctant Supreme Court would not. The debates on the 14th Amendment demonstrate that Congress was to have a central role in realizing the constitutional rights secured by the amendment, continuing the tradition of broad congressional power begun in the 13th Amendment's enforcement clause. The framers were explicit about this. For his part, Senator Jacob Howard left no doubt. In a speech presenting the amendment to the Senate, he explained that the 14th Amendment would change the balance of power between the federal government and the states by giving Congress the power to enforce constitutional rights. Howard said that there is no power given in the Constitution to enforce and carry out any of the guarantees of the Bill of Rights. They stand simply as a Bill of Rights in the Constitution without power on the part of Congress to give them full effect. It is necessary, if they are to be effectuated and enforced, as they assuredly ought to be, Howard said, that additional power should be given to Congress to that end. This is to be done by the 5th section of the amendment. Here is a direct affirmation, direct affirmative delegation of power to carry out all the principles of these guarantees, a power not found in the Constitution as it currently stood. The enforcement clause, Howard went on to say, quote, casts upon Congress the responsibility of seeing to it for the future that all sections of the amendment are carried out in good faith and that no state infringes the rights of persons or property. Now, before closing, I feel obligated to say a few words about the Privileges or Immunities Clause, which has already been mentioned. Thanks to the Supreme Court in the slaughterhouse cases, which I agree with John was wrongly decided, this clause is mostly a relic and ignored as a relic of history. But perhaps even more than the Due Process Clause, it's actually a clear textual route for protecting rights not enumerated in the Constitution, protecting them from state assault. As some of you know, my organization filed a brief in the McDonald case about incorporation of the Second Amendment. We argued that the Privileges or Immunities Clause was textually and historically faithfully incorporated through the Privileges or Immunities Clause of the 14th Amendment, and that was the way to apply it to the states. Now, unfortunately, we only earned the vote of Justice Thomas in that endeavor, and were cast aside by Justice Scalia, who I would argue is not as committed to original meaning as some of his fans would submit, dismissively asked attorney Alan Gura if he was, quote, bucking for a place on some law school faculty by making such an argument. Now, perhaps it's ironic that I think Alan teaches here at Georgetown this year, so, you know, I guess it worked out. But I would say that it's a shame that we did not succeed in our effort to have the Supreme Court explicitly recognize the Privileges or Immunities Clause as a protector of substantive individual rights. Because while people today might not have an immediate understanding of privileges or immunities of citizens of the United States, those words had specific and powerful meaning to those who wrote them into the Constitution. The clause is a powerful guarantee of equal citizenship. States must respect the fundamental constitutional rights of all citizens, and they may not single out disfavored groups and burden their exercise of fundamental rights. So I think that, in conclusion, there is no denying that the 14th Amendment is the keystone of a constitutional revolution in America's history. Its shift of power from the states to the federal government is incontestable, either from advocates from myself or its most vocal opponents at the time of the drafting, up through former Alabama Chief Justice Roy Moore today. But far from wrecking the Constitution and the nation, the ratification of the 14th Amendment was an essential step on the way to making our nation the more perfect union that we foresaw at the founding, and helped us push along our charter further on that arc of constitutional progress. So thank you so much for having me, and I look forward to the conversation.
All right. We've just covered a great deal of territory, and I trust that you now see that my arrangement of the order of battle this afternoon was not completely arbitrary. I would invite your questions at this time. We have about 20 minutes left, so please start lining up at the microphones if you have questions for our panelists. And while you're doing that, I'll invite them to respond to one another, and in particular, perhaps some discussion about the historical understanding of the due process and equal protection clauses that Professor Harrison introduced, and then also the original understanding of the Privileges or Immunities Clause and slaughterhouse and the enforcement power that Ms. Wydra talked about. So have at it.
I don't want to take time away from students who want to ask questions, but I will make one brief comment. Despite all my disagreement with Elizabeth regarding the meaning of the Privileges or Immunities Clause, and the Due Process Clause, and the Equal Protection Clause,
Santa Claus,
and the Ninth Amendment, and the 10th, and McCulloch against Maryland. Despite all those disagreements, her statement That the 14th Amendment was revolutionary, I think, is far more true than most of us realize. It was an extraordinary moment. It led to a breakdown of constitutional government. The efforts to pass this amendment led to the confrontation to the president, and it almost erupted into a second civil war. This was an extraordinary moment. It's worth studying, and I think when you do, you will completely agree with Elizabeth. It was revolutionary.
And on everything else, too, not just that.
Two quick thoughts. First, about Congress's power under Section 5. As is often the case, the really important question is not whether. Yes, Section 5 significantly increases Congress's enforcement power, but how much? Section 5 is the power to enforce the rest of the amendments. That is to say, it is essentially remedial with respect to the substance of the rest of the 14th Amendment. Notice that reproduces, as above, so below. That reproduces the structure of the Equal Protection Clause as I suggested it was primarily originally understood. It's about remedies, and the substance of rights comes from elsewhere. Second point, I want to take this opportunity, since Elizabeth mentioned Dred Scott, to correct a piece of right-wing propaganda that you may have heard. The right-wing propaganda is that the Fifth Amendment holding of Dred Scott is a precursor of substantive due process. Of course it's not. It is 19th century, antebellum, vested rights due process. Chief Justice Taney's argument was that a statute that forbade slavery in the territories of its own force constituted a deprivation of property because it meant people couldn't own slaves. And so it was unconstitutional not because it invaded a fundamental right, not because it was irrational, but because it was a direct legislative deprivation of property. That was 19th century thinking, not 20th or 21st century thinking.
All right, anyone else? Otherwise, we'll go to questions. All right, go ahead, sir.
I'm sorry I was going to have to ask a series of questions. I didn't want to turn into a month-long soliloquy, so I had to pick only one of these parts in order to contest. I would have to ask the panel what they would think about my interpretation of the Privileges and Immunities Clause as only incorporating those particular rights that were enumerated in the Civil Rights Act of 1866, absent from which I would note was also the right to vote, which was why I thought that we would have to pass the 15th Amendment in the first place. If anyone could elaborate on that, I would appreciate it.
Yeah, privileges and immunities, or privileges are immunities, are civil and not political rights. That's right, and that was the dominant doctrine under the Article 4 Privileges and Immunities Clause.
What complicates the issue, and this may be what's driving it, is that a lot of times you'll hear the Privileges or Immunities Clause as linked to the Civil Rights Act, the Civil Rights Act as linked somehow to Article 4's Comity Clause, and Article 4's Comity Clause as linked to Corfield against Coryell and Justice Bushrod Washington's list of fundamental rights that had to be equally extended to visitors as they went from state to state. And in his list of fundamental rights, which included the right to pursue happiness, he also listed the right to vote once you had, subject to certain residence rules established by Congress. That led to, during the debates in Congress, the question about whether or not Corfield against Coryell was the proper guide to understanding national rights. And it was Democrats and opponents of civil rights legislation that ended up raising Corfield against Coryell so many times to throw in the face of the Republicans, hey, you're going to be giving blacks the right to vote, and Republicans having to say, no, 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 don't let anything like that get out into the press, or all of us are going to lose the next election, and many of them did, precisely for that reason. That they abandoned Corfield against Coryell, and they went to different understandings of Article 4, Abbott against Bailey and some others. But the main point I'd want to make is that I think it's absolutely incorrect to link the Civil Rights Act to the Privileges or Immunities Clause. Civil Rights Act had to do with equal protection of certain issues of interest to persons and property. John Bingham described the Civil Rights Act expressly as an effort to enforce the Due Process Clause. He said that more than once. So did the other members, other moderate Republicans. And John Bingham certainly would have understood the Due Process Clause as providing equal protection, as authorizing legislation like the Civil Rights Act. Complicated question as far as the right to vote, but I think all the Republicans certainly would have said we're not trying to do that, and that's why they eventually moved away from Corfield.
Yeah, I would just say that I think part of the reason they went away from that was, for political reasons. But as my wonderful colleague David Gans argues in a narrative that we've released called The Gem of the Constitution about the Privileges or Immunities Clause, we certainly think that if you look at the debates and the text and history, which are extensively laid out in that piece of scholarship, that it shows that the Privileges or Immunities Clause was meant to include the individual rights in the bill enumerated in the first 10 amendments to the Constitution, but also some unenumerated rights. And, that's, I mentioned the brief that we filed in the McDonald case, and we filed it on behalf of scholars from across the ideological spectrum, from Randy Barnett to Jack Balkin, and everyone agreed on that. What they didn't agree on was what those enumerated rights were. So I think that's the conversation that is still out there to have. But there is a substantial scholarly consensus, although there are some notable outliers, that the Privileges or Immunities Clause does include the enumerated individual rights of the Bill of Rights, as well as some to be debated unenumerated rights.
I don't think that Randy Barnett to Jack Balkin really fully crosses the ideological spectrum.
And Steve Calabresi.
We can talk
as well.
about this.
Yes.
We can talk about this.
Steve Calabresi also was on that brief as well. So I encourage you to check that out too. It's McDonald versus Chicago, our amicus brief.
All right, thank you.
Well, that's
Next.
a good segue to the divide. Just a question for Ms. Wydra about Roy Moore. And since I don't want to be the bathwater going out with the baby, is that what makes you use him and pepper him throughout your examples? And what group are you trying to use him as an analogy for when you use him? Because he did lose in a red state, and we all had a sigh of relief when it happened. And I do think MSNBC was quite disappointed when he lost. So I was curious where you use him.
The reason I use him is because I think that it was, well, first of all, having been a state Supreme Court justice who, in my opinion, needed to reread the Supremacy Clause a few times. He is someone who presumably should know the law. The fact that he articulated so very clearly some of the same points that were objected to during the drafting of the Reconstruction amendments, I just find very interesting. I'm not saying he's an avatar of the modern conservative movement.
Oh, good. Thank you.
That's, I just think that...
I can sit down now.
Yeah.
All right, yes, sir.
First of all, I want to thank you all for your time in coming out today. My name is Rusty Lane. I currently attend Hillsdale College, where I'm a member of their undergraduate Federalist Society chapter. I'll start at the Notre Dame Law School this fall as a 1L. So my question is, with respect to the 14th Amendment, the first clause of it, which has to deal with all persons born or naturalized in the United States, comma, subject to the jurisdiction thereof, comma. I'm particularly interested in that latter portion. In particular, what bearing does that language, subject to the jurisdiction thereof, have on the issue of birthright citizenship? Thank you.
Who'd like to field that one?
I have a lot to say on that. I think that if you look at the debates again, when they were drafting the birthright citizenship clause, that clearly, to me, when I read that those documents, suggests that it was a recognition of actual jurisdiction. So the people who were excluded under that were diplomats who are sort of carried in the fiction that they're not really on U.S. soil. They carry this, kind of country with them. So they would be excluded from the traditional rule of the place where you're born being a grantor of birthright citizenship as opposed to bloodline. And then invading armies. So the idea is that, you wouldn't, if you have an invasion from a foreign force, the children of the invading army would not be given birthright citizenship in part of that wartime. So, I think that there are attempts to make it seem more than it is. I think that those, and I've actually written a piece called Debunking Myths About Birthright Citizenship, so I encourage you to read that. But I think that the idea that it doesn't apply to people who come here without documents is totally wrong. I mean, you're still subject to the jurisdiction of the United States. If someone is here without documents and commits, a robbery, they are still subject to process in the United States, and they are subject to the jurisdiction of the United States. Just because someone is here without documents, I don't think renders them outside the jurisdiction. And I think more importantly, when you look at the 14th Amendment's values as expressed in the Birthright Citizenship Clause, but also throughout the first section, what they were looking for was some sort of recognition that everyone born in the United States, essentially can be part of the American dream, that no matter whether your ancestors came over on the Mayflower, on a slave ship, or arrived, from a steamer boat from, the old world, that if you are born here, you are equally a citizen. And we were going to use an objective measure of that instead of bloodline, because that just doesn't fit with American values.
Let me add the third group that they pretty clearly had in mind. I agree with what Ms. Wydra just said. American Indians who had certain political relations with their tribes such that they genuinely were not subject to the jurisdiction of the United States or of the states. Whereas, again, yes, the children born here of people who may have entered the country illegally, may be in the country illegally, are subject to the jurisdiction of the United States.
And I agree with both of the panelists, other than to say I think it's an excruciatingly difficult topic due to the fact that it was under-theorized and under-discussed at the time of the drafting of the 14th Amendment. The main concerns, of course, were to make sure that the former slaves were going to be citizens of the United States and of the state in which they resided. So that was the particular focus. They also needed to make sure that they had power to draft legislation, like they had drafted in the Civil Rights Act, which had its own all citizens born in the United States are, all persons born in the United States are citizens. So they add the clause at the last minute to the 14th Amendment. It was the last addition to Section 1. It wasn't something that Bingham had originally put in there. And it got some last-minute conversation, and the conversations primarily had to do with its impact on Native American tribes. So when you go to the Congressional Globe and you look at the discussions around this amendment, they almost all have to do with how is this going to impact the status of those who we are in these treaty agreements with Native Americans. Then a few people, Higbee from California, a few others are saying, well, how is this going to affect the population that's coming over from Asia? And other people wanted to talk about how is this going to affect gypsies? Yes, I mean, these things are thrown out there at the last minute. They get very perfunctory kind of discussion, and then no discussion whatsoever once you actually go into the ratification period. So determining whether or not there was some type of consensus understanding about and subject to the jurisdiction thereof, I think is discoverable, but I think it's going to take some pretty painstaking historical work, and work that I've not done at this point.
Thank you very much.
Thank you. Next.
Hi, so I was wondering, so Professor Marr was brought up 2 or 3 times, and at least he writes somewhere that I've read that he argues, at least partly, that when the 14th Amendment is incorporated, the Bill of Rights is incorporated through the 14th Amendment, that it actually incorporates the public meaning, not at the time of the original Constitution, but after the Civil War and that time. I was just wondering your guys' thoughts on whether there should be a different understanding of what the Bill of Rights means applied to states, 1870s, whenever, versus the federal government, 1789.
I guess I'll take a crack at that. I did go to Yale Law School, as did the other panelists. I think, though, I have you all beat. I took 19 credits with Akhil Ahmed out of my 53. So you can find that idea in his Bill of Rights book. And that, there is a sort of logic to it, that if the meaning of one of the amendments in the Bill of Rights was not had changed quite, but was, let's say, misunderstood in 1868, then that misunderstanding is the version that is incorporated. That's a kind of a provocative thought. I don't actually agree with him about that, but you can see the logic of it, that what the ratifiers of the 14th were voting for was the version that was the common understanding then. So that's the thought. I don't actually agree with it, but you can find it in his Bill of Rights book.
Anyone else?
I'm sorry.
Both, no, you go ahead now.
I would, I feel like I'm being challenged to an Akhil Ahmed fan-off by Nick here. I took 2 classes with him, but he's on my board of directors. So. That's a great question, and I think that, as the Constitution has been amended, it does change the character of the document. It becomes a document that, while it originally excluded people of color and women from democracy, is amended to create a more inclusive democracy. And that changes the ideas of many of the principles of liberty and equality that were laid out in the earlier parts of the Constitution. You have to look at the whole Constitution. There's nothing that is privileged of time here. The founders put in the amendment process precisely because they didn't want what they did to be unchangeable. They wanted to capture the wisdom of we the people over time, and we have done that by amending the Constitution in incredibly important ways. I think a lot of his work on the Bill of Rights, and I agree his Bill of Rights book is fantastic, and everyone should read it. If you look at a lot of the debates over the 14th Amendment, it is interesting to see that the way that they have changed conceptions of some of these individual rights. I think the Second Amendment right is one in particular. At the founding, this was a right that was considered to be used by state militias against a potentially tyrannical federal government. And then when you look at the concerns over the right to have a gun for self-defense at the time of the 14th Amendment, there was a lot of discussion about the rights of formerly enslaved people to protect themselves against racist Southern local militias. So the idea of the Second Amendment right as looked at through the prism of the 14th Amendment makes it actually much more about civil rights and ensuring protection for marginalized communities rather than this idea that you can somehow prevent the federal government if they turn tyrannical from taking over. So I think it's a very interesting idea, and to the extent that it encourages us to look at the whole Constitution as something that I wholeheartedly agree with.
Dr. Harrison.
And just briefly, I just want to follow up on this, is that, again, going to Elizabeth's revolutionary point, the question raises a doctrinal problem. Even if we agree that the proper understanding of the Incorporated Bill of Rights is the understanding that they had in 1868, does that lead us to the doctrinal problem of having First Amendment as applied against the federal government carrying a meaning of 1787, and the Incorporated First Amendment meaning carrying an 1868 meaning as far as states are concerned, so having this asymmetric approach? If you think of this moment as revolutionary, if you think of the actions of the Republican government as something being extraordinary, almost a constitutional convention of sorts, then you could look at the 14th Amendment as actually refounding the Constitution and refounding a new idea of what the privileges or immunities of citizens of the United States, whether applied to the federal government or the states, are concerned. It inaugurated a new understanding that would apply both against the federal government and the states. But to take that position, you have to believe there was something revolutionary going on in 1868.
Maybe just actually one other little thought on this. So yes, Akhil does have the suggestion that we should incorporate the understanding from 1868, but that's really like a very small, that's a small piece of the claim. The much larger, more important claim is that when you talk about incorporating the Bill of Rights against the states, it's crucial to separate out the individual rights components of the Bill of Rights, and that the Bill of Rights is largely, primarily perhaps, about structure, about separation of powers and federalism, and that some of those things just don't sensibly incorporate. It doesn't quite make sense to incorporate those against the states. And one kind of provocative example is the Establishment Clause, but I'll actually offer another one. Consider the Third Amendment. So, no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Maybe I haven't spent a lot of time thinking about this amendment, but consider this is not actually an absolute right against having soldiers quartered in your house. It's really a separation of powers mechanism, right? The president would do the quartering. The Congress could authorize it, right? If it was prescribed by law, Congress authorizing it. So it's a sort of a separation of powers provision and actually mirrors the separation of military power that we see in Article 1, Section 8. So it maps on to a sort of separation of powers idea, and not clear whether or how that ought to sensibly incorporate, right? States don't quite have the same mechanism, and so it may not incorporate in quite the same way. That, I think, is a much more important idea than this idea of the misinterpretations of 1868 and whether or not they should be incorporated.
That question does raise a recurring interpretive question to which there is no standard answer, and that is what to do when one legal provision is adopted on the basis of an assumption about the content of the law elsewhere, and that assumption is false. Because almost certainly most of the people who had views about what, say, the First Amendment meant in the 1860s that were different from the original understanding of the First Amendment also held the belief that they weren't different from the original understanding of the First Amendment. That is to say, they got into that position because they had a false belief about what the First Amendment originally meant, which they thought it still meant. And so that raises the question, if you care about sort of their intentions, their understandings, which of their understandings to honor? The one about the content of the rule, or the one that they were not departing from the original understanding of the rule? And as I say, there is no standard answer to that question, because both of those are going to be components of their understanding.
All right, and I apologize, that takes us right up to our hard 3:30 break time, but I'm sure the panelists will stick around to take your remaining questions, so come on up for that, and please join me in thanking the panel.
Thank you.